Okay, I want to cover a subject here. This is important for the Second Seminole War. I want to go over the actual Florida Territorial slave laws that were in effect during the Second Seminole War. Most of these were passed by the state legislature and became law in the 1820s, and there's a few revisions in 1832 and 1834, and covered one of them in a previous video. Um, so anyway, I retrieved this book from the state library, the actual territorial laws in the state of Florida. If I can get this working, I don't have my portrait or picture up here because I'm having some technical issues due to 8-year-old laptop computer, and also Zoom upgraded, and the newest upgrade doesn't handle my live video feed very well. So anyway, I'll just do it this way. Um, of course, as well known is about the when the Seminoles rose up to remain in Florida, they also had about 1,000 free blacks, former slaves, allies who had adopted some of the culture and lived alongside the Seminole and Miccosukee people and fought for their freedom. And of course, that was a big point of contention between the white population that was afraid that these black people would rise up and kill all the white people. And they actually had precedents for that happening in Haiti, I think in 1832, and also Jamaica. So there's a real precedence or real reason for the white population to panic of a slave uprising. A few years earlier in 1810, there was a uprising in the New Orleans. About 500 slaves rose up and were brutally suppressed, many of them killed. And that's part of history that's not talked about much. They did have the reenactment of the actual event, I think on around the 200th anniversary. So anyway, let's dive into the territorial uh, slave laws here. From the state library, I found the book of territorial laws from 1839. First page, it's by John P. Duval. Governor William Pope Duval was the territorial governor from 1822 to 1834 when many of these laws were passed. And then John Eaton was governor. And now, when this book was printed in 1839, Richard Keith Call was governor. Often the governor would be out for long periods of history and travel or visiting family if they had to go out of state. So there would be an acting governor, and that's uh, at this point in time, it was John Pope Duval, the brother of William Duval. And John Pope Duval, he's not well known like William, but they were very important in Florida territorial politics. John remained here in Florida, and William Duval, he went to Texas. Then he went to Washington, D.C., and both of the brothers died in 1854. Kind of coincidence there that they died the same year. And of course, on the next page, it's handwritten note to A. Edmondson, presented by Thomas H. Duval. That is the son of former territorial governor William Pope Duval, Thomas H. Duval, and he was he was also involved in Florida politics and lived till 1880. It's interesting that another son of Governor Duval was Burr Harrison Duval, who lived from 1809 to 1836, and he was killed at Goliad. So, the Duval family's tied in very strongly with the history of Florida and Texas, which was the things that were going on at that time. So, without much comment, let's just jump into the territorial slave laws. And if you want to read or zoom up into this, it's okay if you just pause the video that I recommend and There's so much of this information, I'm going to have to break it up in more than one video. And also, I will, just have to cover a portion here, and then we'll probably get too long, and I don't want to try to cover everything in one video because it would end up being an hour and a half or 2 hours. So I'm going to break it down into about half an hour presentations. So on the left-hand page, this from the Territorial Laws of Florida, page 215, down at the bottom, an act providing for the collection of judgment against free Negroes and other persons, passed in February 4th, 1832, and repealed in 1834. Following page on the right, page 216, an act relating to the crimes and misdemeanors committed by slaves, free Negroes, and mulattoes. Now, a mulatto is a person of color that they have one parent who is Black and the other who is Native American or white. So they have a biracial or more parentage. And Section 1 of the crimes and misdemeanors committed by slaves, free Negroes, and mulattoes, and this determines who shall be deemed a slave. It says importation of foreign slaves is prohibited, and it basically says that slaves are in that status for a lifetime. Slaves are descended from other slaves. No slave may be brought into the foreign territory in from foreign territories or outside the United States. Slaves convicted of crimes elsewhere may not be brought into Florida. And this pretty much aligns with the federal slavery laws at the time. So pretty much you could not legally import slaves from another country by after 1809. And slaves are slaves who were born of slaves in Florida at the time. Section 2, importation of slaves convicted of crimes are prohibited. It is unlawful to bring into the territory slaves that are convicted of any offense. Slaves cannot be sold or purchased knowing they are convicted of crimes elsewhere. The fines for this would be $250. And fines will go towards a literary fund. So a lot of these fines imposed by the court go to the educational fund, which I find kind of ironic. It does not apply to any slave passing through the territory. So if there's a slave passing through the territory, not staying at Florida, this law does not apply to them. And a question I asked is, how much are these fines in today's dollars? So this section contains a fine of $250. You go into Google, see what $1 in about 1834 equals how much today. So $250 in today's dollars would be $8,750 in today's money. So if anybody's caught with a slave that they've brought to Florida that's been convicted of a crime elsewhere, they have almost $9,000 as a fine. So it's quite a lot of money. Also, this time that people don't carry a lot of money on them. Section 3. Now I'm kind of paraphrasing each section instead of reading everything from word to word, which would kind of put you asleep. So I try to break it down in the basic language that we can understand today. Section 3, certificate of a company importation of slaves. So any slaves brought into the Florida Territory need to be licensed. Any licensing of slaves brought into the territory from elsewhere. Page 217, it says any slaves, either Negro or mulatto, above 12 years of age, brought into the territory must have a certificate signed by a judge with the county court, which shall have a description of stature, height, complexion, name, age, sex, and have not been guilty of committing crimes of murder, burglary, arson, or other felony prior to be brought in the territory. So in Florida at this time, you had to register your slaves, much like registering a car, and you get a license from the clerk of court. Section 4, on the sale of a slave, the certificate is to be recorded. Any person who brings slave into territory to merchandise shall be registered with the clerk of court where the slave shall be sold. Recording the certificate shall be $1 each. And that's $30 in today's money about. So anybody who brings slaves into the territory shall just register them and register the sale. Section 5, anyone who doesn't have the sale recorded with the clerk of court shall be paid a fine of $50 for every slave purchased. Fines shall go to the literary fund. So that so $50. So that's about $50 fine at that time times 30 would, I think, be about $1,500. So if you don't register your slave with the clerk of court, you have a fine to pay. And it'll get better, I'm sure. It'll get more outrageous as we go on. Section 6, anyone registering a fraudulent certificate with the clerk of court, it's like taking a vehicle and having a fraudulent VIN number or something, shall be fined $500 for each slave. Slaves trespassing, Section 7, any slave who shows up on a plantation without a written pass from his master, employer, or overseer, not on lawful business, it shall be lawful for the owner or overseer of the plantation to give the slave 10 lashes on his or her back. So a slave is not allowed to go to another plantation without written pass from their master, employer, or overseer. If they're caught, they'll receive 10 lashes. Okay, Section 8, license to buy or sell. No slave shall buy or sell without a pass from their master, employer, or overseer. So slaves are not allowed to set up a blanket at the flea market and sell anything without a written pass from their master or employer or overseer. Excuse me. Any slave uttering such pass or buying or selling articles without a pass shall receive not exceeding 39 lashes. Anyone allowing a slave to buy or sell without a pass shall be fined $50. So if the master allows his slave to be buying and selling at the flea market without a written pass, then the master shall be fined $50. And the slave will receive lashings not exceeding 39. So the master won't get whipped, but they'll be fined financially. And here's a good part, section, where are we? Page 218, section 9. No free Negro or mulatto, except in the city of St. Augustine, Pensacola, which are governed by local ordinances, shall keep or carry any firelock, military, or other weapons, or any powder or lead without first obtaining a license from the local justice of the peace. The justice may at any time withdraw this license by an order. Any free Negro or mulatto shall forfeit all such arms and ammunition for the use of the informer. So that means even if you're a free person of color, Negro or mulatto, you're not allowed to own firearms. The Second Amendment does not apply to you. The Constitution does not apply to people of color. And that's one thing I'll emphasize, which is not taught. People are not equal at this point. And they also need to have a license issued by the local judge or justice of the peace to own a firearm. If not, they shall forfeit their arms and ammunition to the person who informed on them. So if somebody sees them with firearms or ammunition or knows that they have it, they just report this to the local judge or sheriff who hauls them to court, and the person who informed them, if the gets to keep that firearm with the arms and ammunition. If the free man of color who owns the firearm, if they're not able to prove that they have a license from the judge. Seems kind of subjective how it end up to. Section 10, it shall be the duty of the local constable or sheriff to give any information in prosecution against any free Negro or mulatto in the above act. So the sheriff has to provide any information on the above. Section 11, penalty for the second offense. Any free Negro or mulatto convicted of keeping or carrying of firearms or ammunition a second time, it shall be forfeited, as mentioned previous, and fine not exceeded $20, and or stripes not exceeding 39. So if you're a free Negro or mulatto, and it seems like freeze, uh, kind of a very thin definition here. If you have a second offense of keeping or carrying firearms, you'll be fined not exceeding $20 and be whipped not exceeding 39. So this would also exclude any free person of color from serving in the soldier in the militia, but they can serve as a servant, like a cook or baggage carrier or something of that sort, but they're not allowed to be armed. Section 12, anyone 1/4 or more of Negro blood shall be deemed a mulatto. So anyone, even if you had one grandparent who was a person of color, would make you a person of color as well. So just no fault of your own, just who you are from your family would make you a mulatto. Section 13, acts against assembly, riots, unlawful assemblies, quarrel, fighting, trespassing, or seditious speeches by free Negroes and mulattoes, slave or slaves, shall be punished, fines not exceeding $20 or 39 stripes. So basically what this says is you have no right of assembly, you have no right of having rallies or speaking at rallies. So today, of course, that would be no Black Lives Matter rallies or marches. Sort of kind of not too different today, what's being imposed, that there's no rallies allowed. And of course, Section 14, if you're a white person participating in these rallies, any white person in company of free slaves, free Negroes, or I'm sorry, with slaves, slaves aren't free, of course, free Negroes or mulattoes, and unlawful meeting or assembly participating with them shall be brought before the local justice of the peace. So if you're a white person marching in solidarity with these people of color, then you are also guilty of rioting or sedition or unlawful assembly, and you are brought before the judge. And you will appear in court, and upon conviction, not exceeding $100 for every offense. So that's over $3,000 fine for each person in today's dollars, or you shall receive 39 lashes or imprisoned not exceeding 2 months. So if you're a white person, the penalty is very strict. If you're standing in solidarity with the free people of color, you can be fined a lot of money, be whipped up to 39 times, or imprisoned not exceeding 2 months. Section 15, page 219, duty of the justice of peace. Within 10 days after the above described unlawfully assembly or meeting, the justice of peace will issue a warrant for apprehension of the people assembled and bring them before for trial or punishment. So as a judge or justice of the peace, you have 10 days to bring them up for trial. Section 16, any Negro or mulatto, slave or free, shall be a good witness against any other Negro or mulatto. So Negroes or mulattoes cannot use the court to sue anybody, but they can be a witness and testify a court against other Negroes or mulattoes. So they don't have right to use the court system, but they'll be taken as a eyewitness. Section 17, buying from slaves on the Sabbath. Anyone on the Sabbath who buys or sells from any slave without consent or the master of the slave in writing shall be fined $5. So there's no doing business on the Sabbath unless you have with any slave, unless you have a written consent from their master, or you'll be fined dollars. So the fine's not too bad for that. Section 18, an owner permitting a slave to trade. If a master or employer shall license a slave to go at large and trade as a freeman, except in Pensacola and St. Augustine, which have other laws, the master or employer shall be fined $50. If the slave is also convicted, they'll be fined the same. Okay, page 220. Section 19, anyone allowing a slave to act as a trustee, guardian, executor, or administrator, except in Pensacola or St. Augustine, shall be fined $50. So a slave cannot do a power of attorney. Okay, section 20. This is a long one. Slaves offering articles for sale without a license may be arrested or purchased. So a slave cannot sell anything. Any citizen of the territory, so that's any white person who just comes by and finds that a slave is offering anything to sell at the flea market without a written permission from his master, they can apprehend the slave, take him before the justice of the peace. The justice can permit the person who apprehended the slave to receive the articles that the slave was selling, and the slave shall receive 10 lashes as long as such articles are not stolen. So any white person going along sees a slave or a black person selling something at the flea market can try to arrest or apprehend them, take them before the judge, accuse them of selling goods without the permission. And if they are found out to be true, then the white person gets to keep what the slave was trying to sell. That's a bit outrageous. Section 21, any free Negro or mulatto who sells to any slave or slaves ardent or intoxicating liquor shall be fined $10 and receive up to 39 lashes. So any free person of color cannot sell liquor to slaves. Section 22, any Negro or mulatto, slave or free, who uses abusive or provoking language or lifts his hand in opposition to any white person who is not a Negro or mulatto, proved by an oath of the offender, shall receive up to 39 lashes unless a Negro or mulatto was wantonly assailed and assaulted and lifted their hand in their own defense. So any person of color, slave or free, cannot even give the finger to a white person. And if the white person says they did it, even on their word, the court can go ahead and give them a whipping up to 39 lashes. So as a free person of color or slave, you can't even tell abusive white person where to go, tell them to pound sand. So you have no right to free speech or anything. Well, I'm going to cut it off right here. We'll continue next time on page 221 in section 23. and hope you found this informative. And we shall do this again. Stay tuned for part 2.